Alright. Hello. Alright. I made a video soon after a couple of really bad Supreme Court rulings. Or should I say Supreme Anarchist rulings. And over the weekend I was thinking, they have not always been wrong on everything. I'm going to make videos on my YouTube channel where I thank the Supreme Court for getting it right. And 3 decisions where they got things right, that were the first 3 that I could think of. I even remembered the names of these decisions without looking them up. I did look up the exact year, so I know they weren't last year, but exactly how I might have been off by a year or 2 if I didn't look that up. I'll take these 3 in chronological order. Chronological order based on the year. I didn't look up the month. Maybe one of these was a month before the other. In 2008, the Supreme Court correctly decided the Heller case. Dick Heller was an armed security guard or a police officer for his job was working at a federal building, and aside from the judicial and legal implications of this case, this case is a great illustration of the absurdity of gun bans. We could trust this guy Dick Heller to have a gun on the clock to protect important government workers, leaders, and buildings, but according to Washington, D.C. City Council, we couldn't trust the guy to have one at his house too. That's absurd. If we could trust him to have one in one place, we could trust him to have one in another. The main question that was answered by this case is, does the Second Amendment mean the people when it says the people? Well, that's the way I would summarize it, because it's obvious what the Second Amendment means. But for those who are trying to do mental gymnastics to avoid what they don't want, they can do some amazing mental gymnastics. The people is not only in the Second Amendment. It is written in other parts of the Constitution, other parts of the Bill of Rights. If the people doesn't mean the people, general public, individuals getting to do stuff, then the government has the right to require you to get a permit to be allowed to petition the government. The government can break up peaceable assemblies and only let the National Guard have peaceable assemblies. If the people means the National Guard, the most absurd thing about that false idea that the Second Amendment was written so that the government wouldn't be disarmed, really, it just takes an extreme amount of absurdity or lack of intelligence or delusion to think that the Founding Fathers were worried about the government becoming disarmed. Although maybe there is something to that. I mean, recently in my lifetime, recently compared to the history of the nation, President Clinton did stop the military from having guns on military bases. But still, the Founding Fathers didn't mean that. Next case, McDonald. Heller resolves the issue correctly of what constitutes the people that get to have guns, and to some degree what guns it is. That's the one that said that it has to be the commonly allow the guns in common use. So if you wildcat your own weird caliber, that does not get the same protections as that caliber that's being mass produced, that you can go to the store and get ammunition for. that there are millions, scores of millions of guns with that caliber out. Heller did not force the states and cities to respect our basic human right of self-defense and tools of self-defense. Because the Heller case was about Washington, D.C., which is not a state, which has a unique legal situation, and that the Constitution, all those things that the Ninth and Tenth Amendments prohibits Congress from doing, they've got one place they get to do it. That's Washington, D.C. And so Washington, D.C. is unique in that way. The 14th Amendment, of course, was written because the Democrats who fought the Civil War to prevent the abolition of slavery and to continue slavery had decided after they lost the Civil War they were not going to treat these freed slaves like human beings and give them their basic human rights. They passed Saturday Night Special bans, or in other words, bans on guns that a dirt poor, recently released slave is more likely to be able to buy. Recently freed from that immoral institution. So the 14th Amendment, one of the things that it does is it says that the rights granted, enumerated in the Bill of Rights, those count everywhere, and they apply to the states too. Before the 14th Amendment passed, it was held that the federal government couldn't do these things in the Bill of Rights. The federal government couldn't disarm you. The federal government couldn't have an official religion. The federal government couldn't persecute you for your religion. But if a state wanted to, that would have been fine. So, at issue in the McDonald case, this was in Chicago. Otis McDonald, if I'm remembering his first name right, in 2010, was when the ruling came out, was a man with a clean criminal background who wanted to have a gun to be able to defend himself. And the Supreme Court correctly ruled that yes, the right enumerated in the Second Amendment of the Constitution, that counts with all the other rights enumerated in the Constitution towards the 14th Amendment, so cities and states had to respect the people's right to keep and bear arms. Good job, judges. Chief Justice Roberts, you were great. I'm saying his name because on my video where I was ranting, I think I said his name. One about a Supreme Court case he was wrong about. Now the third ruling I want to cover today. Citizens United wanted to use their First Amendment freedom of speech, freedom of the press, right of assembly to get themselves together, make a video, and distribute it. It was a documentary about a candidate. And it was illegal. I put my fingers up like that because the law that made it illegal was so painfully, obviously unconstitutional and immoral and stupid. And a reason that in 2008 I was pinching my nose when I pulled a lever at the voting booth. The reason in 2000 that I voted the way I did in the primaries. I wouldn't be surprised. I bet that's why John McCain lost the primary election in 2000 was because Americans did not want our First Amendment freedom of speech trampled. And the main thrust of John McCain's campaign in 2000 was, I will, make it illegal for you to peaceably assemble, gather your money together, you poor people who aren't billionaires that can't spend $100 million on TV advertisements and not break a sweat. and speak about the issues. Alright, so in 2002 is when that passed and was signed. One reason I regret one of the things that George Bush did wrong was signing an obvious, complete violation of our First Amendment freedom of speech when he signed the officially named Bipartisan Campaign Finance Reform Law, aka McCain-Feingold. So the Supreme Court got it right when they said, no, so many days before an election, the freedom of speech doesn't get thrown out the window. What's most ludicrous about this law is the most important speech for us to have with our kind of government is political speech. If the government wants to ban car dealerships from telling you they're the best car dealership, they shouldn't do that. Maybe that's covered by the First Amendment also, but it's not as much a big deal and not the end of the world. Like, if I don't get to find out about a history, life history, voting history, work history of candidates, especially a candidate for the president, then maybe the world isn't going to end if the guy running for dog catcher I don't get to find out about him. And of course, Citizens United was the name of that case because Citizens United was a group that made a documentary about Hillary Clinton. Thank you for watching this video. Thank you, Supreme Court, for all of those good decisions you've made. I have not, in my mind or on paper, tried to figure out what percentage were good decisions and what percentage were bad decisions. One last thought. One time I saw somebody up in front of a classroom say that the reason we have 5-4 Supreme Court rulings is because people have different opinions. And maybe there are some issues that are a little bit vague. The Constitution does not specifically list what is cruel and unusual. It just says no cruel and unusual punishments. So there are some scenarios where a 5-4 decision is reasonable, but most 5-4 decisions are because there were 4 or 5. You'd have to look up the specific decision to figure out which of this case. There were 4 or 5 of them that were completely ignoring the Constitution and making up whatever bullcrap they wanted to. And 4 or 5 of them that were actually paying attention to what the Constitution says, what the Founding Fathers wrote, what the Constitution meant, what the law says. Thank you. Have a good day. Thank you, Supreme Court, for those good rulings that have come out. And I do not apologize for calling the Supreme Court supreme anarchist, because we don't know when we're going to get a good decision from them and when we're going to get one of those jaw droppers that makes us say, huh? This is not why they had have life tenure. Have a good day.